we participated as an amicus in this case that was heard last week at the New Jersey Supreme Court. DeMarco v. Stoddard, it was a case largely dealing with the parameters for an insurance carrier rescinding a contract on an insurance policy that was obtained with fraud, and that's for the benefit of an innocent third party. Shalom wrote our amicus in this case, and he is going to discuss a little bit about the case and mostly how oral argument went. It was a really interesting conversation, and Shalom has been practicing for 27 years in New Jersey. He was nominated by President George W. Bush to the Third Circuit in 2007. He is now a partner with Brown Moskowitz Kallen in Summit, and I'm going to turn it over to him.
Thank you, Alita. Welcome, everybody. So I'm going to talk today about what took place in court. We'll talk about the background of the case, the appellate division's ruling, and what went on last Monday before the justices, and I will try to tease out from the court's questions on the colloquy what we might expect to hear from the court in a few months. So we'll start with what's before the court. The question presented, I think, accurately captures at least one of the questions before the court. The question is, where a medical malpractice insurance policy is voided based on a fraudulent application, must the issuer of the voided policy pay liability claims of the third parties, and if so, what is the amount of coverage? So we've got in this case a fraudulent policy which is being voided, and the third party, in this case a patient, wants coverage from the carrier. Note that the question presented does not address the choice of law issue, which you'll hear is going to be a large part of what turned out to be the briefing and the argument. So this case goes back to a podiatrist by the name of Stoddard. He applied to the Rhode Island JUA for coverage back in 2007. The Rhode Island JUA provides coverage only if the majority of your practice, 51% of your practice, is in Rhode Island, and Dr. Stoddard falsely represented that, in fact, his majority of his practice was in Rhode Island. That was not true. He later admitted that that was not true. As a result of that misrepresentation, Dr. Stoddard was able to secure coverage from the Rhode Island JUA for 2007 through 2011. Now, Dr. Stoddard, being a New Jersey licensed podiatrist, had patients in New Jersey. One of them was a Thomas DeMarco. Mr. DeMarco had foot surgery from Dr. Stoddard in 2010. Surgery did not go well. As a result, Mr. DeMarco sued Dr. Stoddard in New Jersey in 2011. Dr. Stoddard then picked up and moved to California, leaving his mess behind him. Dr. Stoddard tendered the malpractice suit to the Rhode Island JUA. Meanwhile, the Rhode Island JUA filed a DJ action in Rhode Island in 2012. Dr. Stoddard defaulted on that DJ action, and the Rhode Island court declared the JUA policy null and void based on Dr. Stoddard's misrepresentations. Significantly, the DeMarcos were never served in the DJ action in Rhode Island, and no rulings were ever made by the Rhode Island court directly against the DeMarcos. Now we come back to the New Jersey courts in the malpractice case. The DeMarcos filed a DJ action against the JUA, arguing that the JUA should be required to provide indemnification. The JUA cross-moved, arguing that they did not have to provide indemnification. Ultimately, the trial court granted summary judgment for DeMarco. The trial court ruled that the Rhode Island ruling is not binding on DeMarco because they were never served. The trial court also ruled that the JUA must indemnify Dr. Stoddard up to the $1 million, in the amount of $1 million, which was the policy limit. The appellate division granted leave to appeal. This was an interlocutory ruling. Summary judgment had not addressed some other issues. The appellate division granted leave to appeal, and the trial court granted a stay of the balance of the case pending the interlocutory appeal. So we move to the appellate division. The appellate division issues a ruling as follows. First, as to the Rhode Island part of the case, the appellate division in New Jersey holds that the Rhode Island decision is not binding on DeMarco. That issue, that part of the appellate division's ruling is not before the court. Nobody really is challenging that aspect of the decision. Next, on choice of law, there's an extensive discussion about whether the appellate division should be applying New Jersey law or Rhode Island law. The law division had applied New Jersey law. The appellate division finds that New Jersey law and Rhode Island law are sufficiently different on whether the policy is rescindable, and therefore a choice of law ruling is required. The appellate division says that the doctrine of lex loci, the location of the contract or the tort, is no longer followed. And so the appellate division says we're going to have to follow either the governmental interest test or the most significant relationship test, which are fairly similar. The court then discusses briefly whether there's a difference in whether this is a tort case or a contract case, and whether the difference between the two, whether rescission is a tort or contract case, is really going to impact on the choice of law decision. That's an interesting discussion, but which the Supreme Court itself later only discusses very briefly, and it'll be interesting to see if the difference between tort or contract comes back later in the court's decision. But the appellate division only briefly addresses it and ultimately says, for choice of law purposes, they're going to focus on the factors that are listed in the restatement, Section 6, the traditional decision as modified in New Jersey in the Lonzo decision, and the appellate division holds that those factors favor New Jersey. So the appellate division says we're going to apply New Jersey law to this rescission issue. So moving to the rescission issue, the appellate division says, relying on New Jersey's body of law concerning automobile insurance, New Jersey has a history in automobile insurance holding that automobile policies cannot be rescinded after the date of the claim, after the accident. The appellate division holds that Dr. Stoddard's JUA policy cannot be rescinded as to the patient DeMarco. If the insurance policy is compulsory under New Jersey law, it cannot be rescinded. So that's the crux of the appellate division's ruling. Because a med-mal policy is compulsory in New Jersey, it's similar enough to automobile coverage in New Jersey, which is also compulsory. So the appellate division lays out this new rule of law that compulsory insurance in New Jersey cannot be rescinded. Because med-mal insurance is compulsory in New Jersey, med-mal insurance policies cannot be rescinded. Then the appellate division moves to discuss the amount of the indemnity. It's a very brief discussion, and it simply says that like automobile insurance, in which the amount of the indemnity which cannot be rescinded is the minimum that's required by New Jersey law, which for auto is $15,000. Since the mandatory coverage in New Jersey for doctors is $1 million, the minimum amount mandated by New Jersey law for purposes of Dr. Stoddard's policy is going to be $1 million. So that's the appellate division's ruling, that Dr. Stoddard's policy cannot be rescinded as to $1 million in coverage. So the case goes up to the Supreme Court on the JUA's motion for leave to appeal, and that motion is granted last June, June 23 of 2014. The Supreme Court takes the case. The New Jersey Civil Justice Institute files an amicus brief. My brief, the brief we put together, addresses a number of important issues. First, we discuss rescission in New Jersey, the long-standing history of rescission in New Jersey. Rescission is a long-standing part of New Jersey law. And New Jersey law recognizes that rescission as an appropriate remedy when a policy is fraudulent. A policy can be rescinded and should be rescinded when there's a statement that is untruthful, when that untruthful statement is material, and when the insurer reasonably relies on that statement. So we have three elements: untruthful, materiality, and reasonable reliance. As long as the insurer can satisfy those three elements, then the trial court, in its discretion, and it is a discretionary test, even if those three elements are met, but the trial court has the discretion to then rescind the policy. Auto insurance has historically been an exception, but it's a unique exception. The reason it's a unique exception, and then I'm simply tracking what we argue in our brief here, the auto insurance is a unique exception for several reasons. First, because it has its origins in New Jersey legislation. Under NJSA 39:6-48A, the New Jersey legislature has said that auto insurance cannot be rescinded after the date of the accident. Secondly, auto insurance is different than other types of policy because everybody has insurance. Everybody is a driver. Everybody has coverage. Everybody expects every other driver on the road to have coverage. So everybody who's out there on the roads expects everybody else to have coverage. So there's a mutuality concept. There's an expectation concept that everyone's going to have coverage, and so we don't want anyone out there thinking that to go out there, get in an accident, and suddenly discover that the other driver doesn't have coverage. The third reason is because it's a relatively inexpensive solution to a problem of non-coverage. After all, we're only adopting this non-rescission idea in the auto realm for $15,000-$30,000, as opposed to what the appellate division did here, which was force the JUA to non-rescind for $1 million. We also discussed in our amicus brief that the ruling would likely cause an increase in premiums. That would result in honest doctors paying for dishonest doctors, driving doctors out of New Jersey. Some of the other amicuses elaborated on that with some statistical data on how the premiums would be driven up in New Jersey. We also discussed in our brief the fact that there's no precedent for extending the principle behind the automobile policies to any other arena. The only other area where this issue has come up at all is in legal malpractice policies in a case called Lawson. Lawson held, in fact, that a legal mal policy can be rescinded. In that case, the court held that a legal policy, which is mandatory for certain types of law firms, certain types of coverage is mandatory, and in that case, the court held that the legal malpractice insurance policy was rescinded even as to a claim by an innocent third party, and even though the policy is mandatory. So the only other precedent other than auto says that mandatory insurance can be rescinded. And we also pointed out that there were many types of compulsory insurance out there, both compulsory under state law and even compulsory under federal law, that the appellate division never considered what the implications would be. There's workers' comp insurance, there's hazmat insurance, all types of insurance, and the appellate division did not consider what the implications would be of a broad holding that says all types of compulsory and mandatory insurance cannot be rescinded. Significantly, the NJCJI took no position in our amicus brief. We took no position as to whether the JUA policy should be rescinded under the traditional rescission analysis. It's not. We're addressing the appellate division's broad ruling about compulsory insurance not being rescindable. We did not address how this particular case should come out, given the facts as between Stoddard and DeMarco. That's not something we got into. So the argument before the Supreme Court last Monday, I would say it's my opinion. The argument was fairly long, even under New Jersey's Supreme Court's fairly lax standards, no red lights and green lights, but it was fairly long. It was fairly fragmented partly because of the multiple issues that the court was addressing, which I've already alluded to. They were discussing choice of law. They were discussing rescission. They were discussing the summary judgment standards. They were discussing the amount of rescission. So there were multiple issues that the court had to address. It was also a little unusual because the arguments clearly went well beyond what was in the brief, certainly went well beyond what the briefs were focusing on. And a lot of the argument was spent on a choice of law issue, which was not the focus of the briefs below. The JUA's argument before the Supreme Court, not surprisingly, was focused on issues that are specific to the JUA. They were arguing that their unique position as a state-created entity by the state of Rhode Island puts them in a unique position, that they have no underwriting discretion, they do not have the resources to investigate representations, that they take all comers who have a Rhode Island license and have a majority practice in Rhode Island, are required to provide them with policy. The JUA also was arguing that rescission should be guided by equity, should be distinguished from auto cases. They argued that the JUA is not authorized to even issue a policy in New Jersey. So those are some of the issues the JUA was focusing on. So let me talk for a couple of minutes about what happened during the court's questioning, during the colloquy, and I'm going to sort of combine my discussion of the court's colloquy, the Q&A part of the opinion of the arguments, with some, I'll step out on a limb and sort of try and predict where I think the court's going based on what we heard last Monday. So let me start with the choice of law issues. The court, the JUA was arguing, of course, that in Rhode Island, med-mal insurance is not compulsory. Rhode Island has the most significant relationship to this case. I think several judges were skeptical of that argument. I think they spent more time than I anticipated on the choice of law issue, but at the end of the day, I think several of the justices are leaning towards New Jersey law regardless. I believe Justice Rabner, Justice Albin, Justice Cuff were all leaning towards New Jersey law. Justice Patterson, I think, was the only justice who was openly leaning towards Rhode Island law. Justice Solomon, I think, is leaning towards New Jersey law. I think, in all likelihood, I think the justices are going to end up applying New Jersey law and affirming the appellate division on that issue. I think my sense from argument is the numbers lean towards New Jersey law on the choice of law issue. That's just my prediction based on the questions that were being asked by the different justices. Dealing with the rescission issues. So the core issue, obviously, at least from NJCJI's perspective, our concern was the appellate division's holding that any form of insurance that is compulsory, at least compulsory under New Jersey law, is not subject to rescission for fraud. There was surprisingly little discussion of that core holding during the argument Monday. Justice Lavecchia repeatedly emphasized through her questions that there's no precedent for the appellate division's holding in that regard. Justice Albin asked repeatedly what policies would be subject to rescission and which ones would not. But that aside, there really was not a lot of discussion about it, and I think given what was being discussed at argument, I think there's little support among the 7 justices for an affirmance of that holding. I think at the end of the day, I think the court's going to go in a different direction. I think the only justices who really were inclined to support that core holding, perhaps Justice Solomon and perhaps appellate division Judge Cuff might be inclined to affirm. I think Justice Lavecchia obviously is definitely opposed to that holding. Justice Albin seemed skeptical. The others didn't seem to comment on the core holding at all, but my sense is the court is not inclined to affirm the appellate division on that core issue. Which brings us to the summary judgment issue. After all, this was granted on summary judgment, and a good part of the argument involved the court's comments on the fact that this was a summary judgment ruling, and that assuming all facts favorable to the JUA, which was the party that lost, summary judgment would not be appropriate. And I think the reason the court's going to lean in that direction is because there was very little fact-finding by the appellate division. There were no direct holdings made. And the reason there was no fact-finding or holdings made, frankly, is because the court was not making a traditional rescission analysis. The court was making a ruling as a matter of law that compulsory insurance is not rescindable. So they weren't going through the traditional three-factor test. Was the statement false? Was the statement material? Did the insurance company reasonably rely? That's not really what the law division did. The law division and the appellate division in particular made this legal ruling. So I think the justices are going to be skeptical about the summary judgment holding. They were in particular skeptical about whether reasonable reliance could be justified on this record and about whether the Rhode Island JUA even had a duty to investigate the truthfulness of Dr. Stoddard's statements about his practice being majority Rhode Island. So my prediction is that the court is going to reverse the summary judgment. As I said before, the court is, I believe, likely to reverse the appellate division's holding that compulsory insurance cannot be rescinded. I believe they're also going to reverse the summary judgment ruling in its entirety. I believe the court's recourse at that point is to remand it to the trial court to address rescission under the traditional exercise of the court's discretion and applying the three factors of whether it's false, whether it's material, and whether there's been reasonable reliance. I think it's even possible that the court might discuss whether summary judgment is even possible on this record or on any record that could be made. It's possible that the court might tell the court below that summary judgment is inappropriate and that the court should simply proceed to a plenary hearing and hear testimony and decide the rescission issue on the basis of a contested hearing. But that's speculation on my part. I think it's my belief that the court is going to reverse on summary judgment and remand. The last major issue is the amount. Now, the amount of the rescission remedy is relevant even if the court does not affirm on the core legal question on compulsory insurance, because if there's a remand for summary judgment or for a plenary hearing, the court below needs some direction as to the appropriate amount. That's not to say the Supreme Court's going to tell the court below what's appropriate, but the court might provide some direction. During oral arguments, it's clear that the court recognized there were a lot of options, whether those options include the New Jersey $1 million compulsory minimum. New Jersey requires all doctors to carry $1 million in med mal insurance. There is another alternative under New Jersey law. New Jersey doctors have the option of carrying a $500,000 letter of credit. That came up briefly as a potential alternative. And Rhode Island has an alternative, even though Rhode Island does not appear to have compulsory insurance. There was a discussion of certain options under Rhode Island involving a minimum 100, 300 idea. The Supreme Court might try to give the court below some direction on where they might go on a remand with those various options. So that's my summary of what I think took place last Monday, where I think the court might go in its ruling. Let me just talk for a brief moment about two other issues that came up during argument that I think will not be decided by the court, but may be relevant on remand or in other cases in the future that might be of interest to everyone on the line today. So, one, whether rescission is barred for a New Jersey doctor with a New Jersey license. The amicus for the plaintiff, for DeMarco, argued that rescission is an inappropriate remedy because in New Jersey, he argues, the doctor's insurance policy must be listed in the doctor's license application or license renewal application. I don't think the Supreme Court's going to address that issue for two reasons. One, because it wasn't raised in the brief below, and it was clear from arguments that there's an insufficient record to get into that issue. And third, because the justices didn't seem to, the questioning didn't seem overly engaged in that issue, but they seemed engaged enough. They were intrigued by the idea. And I certainly think it would not surprise me if that issue were raised on remand or in a different case. But I think it would not surprise me if it were raised even in this case on remand, if DeMarco were to argue on remand that rescission should be barred for that reason. The other issue that came up is whether New Jersey doctors are required to be insured by a New Jersey licensed carrier. So the statute in New Jersey requires New Jersey doctors to carry $1 million in insurance, and the statute specifically says that insurance must be with a New Jersey carrier. Now, Dr. Stoddard was not licensed by a New Jersey carrier. He was licensed by the Rhode Island JUA, which is not licensed to issue insurance in New Jersey. And there were a few questions about that, and a few questions about whether the language in the New Jersey statute about doctors being licensed by a New Jersey carrier is to be read literally. Does that mean that if you have a perfectly valid policy of insurance, but it happens to be from a carrier that's not licensed in New Jersey, does that mean your policy is not valid? I don't think that has any direct relevance to this case. I think the justices were more curious than they were addressing an issue that's going to come up in this case, but I certainly think that's an issue that might come up in another case where a doctor discovers that he's got insurance from a carrier that's not licensed in the state of New Jersey. So that's my summary of what took place in this case below and last Monday, and we can open the floor to questioning.
Shalom, they were wondering if you could address what this ruling could mean for the insurance industry in general.
Sure. Well, I think the most important issue for the insurance industry is the core ruling by the appellate division, which is that mandatory insurance, that any form of insurance that is compulsory under New Jersey law cannot be rescinded for fraud. And I think that's why the CJI got involved. That's why the other amici got involved on behalf of the JUA, because of the concern that fraudulent policies couldn't be rescinded if they happen to be written for an insurance line that's compulsory. So if this opinion were to stand, if the Supreme Court were to affirm, you would find that you've got fraudulent policies that cannot be rescinded, which not only in itself creates a huge financial burden for the insurers, but incentivizes the insureds to be less than diligent and less than truthful in their insurance applications, because they know that the carrier is going to be forced to provide coverage in the end anyway, because the policies are not rescinded and cannot be rescinded. So the huge implication for this case, at its core, is to get a ruling from the Supreme Court that narrows, limits, or reverses the appellate division holding and says, we are not going to go there. We are not going to adopt the appellate division's ruling. We are not going to say that mandatory coverage cannot be rescinded. We're going to allow rescission under the traditional analysis, even where we're dealing with a compulsory line.
Shalom, you indicated that you were a bit surprised that there was as much discussion on the choice of law question as there was at oral argument. Do you have any thoughts on why that was? What precipitated the court's interest in an issue that was not the primary issue in the underlying briefs?
Well, I think the court was thinking ahead towards the remand, first of all, and they wanted to provide guidance. This is, further along my assumption that they're not going to affirm. If they're going to reverse, then there's got to be a remand, and then the court's thinking, okay, if we remand, what law is the court going to apply? Now, of course, they could have just reversed and remanded, saying, okay, we're going to reverse and remand to apply New Jersey law without much discussion. And the court seemed to have a much more of a discussion about Rhode Island law than I anticipated, because I think they were bothered by the fact that you've got a JUA, which is as the JUA argued, it's a creature of state. It's not licensed in New Jersey. They believed that the doctor they were dealing with was a Rhode Island doctor. So from a traditional insurance perspective and from a state interest perspective, there are arguments that could be made that this really should be a Rhode Island choice of law issue. So I think there are legitimate arguments supporting a Rhode Island outcome. I just don't think that they've got the numbers when all is said and done.
When should we expect a ruling?
Well, the Supreme Court's got a mixed history on civil cases. They'll sometimes announce a ruling in as short as a month or two, but this is anything but that. And so in the more complex cases, their history is about 6 months from date of argument. And so that would be my guess. I would say we're not going to see a ruling in this case until the fall, maybe late fall. So if I'm going out on a limb and making a guess, that would be my guess. I would say late fall.
Can you discuss more the car insurance parallels?
Sure. The auto insurance exception has been around for a long time, and originally it was designed to simply provide a remedy for an accident victim and said, okay, once you had the accident, the policy cannot be rescinded for fraud. Now, certainly the case law has gone well beyond the legislation, so it would not be accurate to say that the auto exception is purely legislative. It started out legislative, but there are all sorts of decisions that go beyond the original statute that create a non-rescission remedy solely as a matter of case law. But this has only happened in the auto world. And it's not unique to New Jersey, by the way. Other states have done the same thing. But in New Jersey, it's an auto issue. And in the auto world, you've got this idea that we want to protect the victim of the auto accident and make sure that they've got coverage, at least that minimum coverage, that $1,530 in minimum coverage. And so we've got this legislation with case law that's grown up around it, expanding it in some other unique circumstances where the check bounce, the premium check bounce in other areas. So you've got this whole exception for auto insurance. Our argument in our brief was that exception should be limited to auto insurance, that there's no policy justification for expanding it beyond auto insurance. And the appellate division actually did very little to explain why it should be expanded beyond auto. There's very little discussion in the appellate division opinion, and I think that's really one of the weaknesses. Interestingly enough, during oral arguments before the Supreme Court, there really wasn't any discussion by anybody, by the lawyers, by the amici, by the parties, by the Supreme Court justices. Nobody tried to argue, yeah, this is a good idea. We should extend the auto exclusion, the auto non-rescission idea. We should extend that to compulsory insurance, and we should do that for the following reasons. Nobody really made that argument before the Supreme Court. And I think that's one of the reasons why I'm predicting that it's going to be reversed, because there just didn't seem to be any interest last Monday for that idea. The appellate division did, I thought, a very cursory job of trying to draw parallels between auto insurance and other forms of insurance, and all they did was say, well, auto insurance is compulsory, And that's why the exception has grown up around auto insurance. That's why the legislature passed this statute. That's why the case law has grown up around auto policy. All of that's because automobile insurance is compulsory. And since we've done that for auto insurance because it's compulsory, we're going to do it for med-mal insurance because it's compulsory. And that was the extent of the analysis. So there really weren't any parallels being drawn beyond this idea of compulsory insurance. And so we were able to argue that there are a lot more differences between auto insurance and med-mal insurance than there are similarities, not just because the amount is so drastically different, but because the whole idea behind protecting the drivers and even pedestrians in the auto world doesn't apply in the med-mal arena. Certainly, the contrary argument was made that the reason why we have compulsory medical insurance is because we have patients, and the patients need to be protected, and that's why the statute was passed. New Jersey passed compulsory medical insurance because the legislature wanted patients to be protected, wanted when a patient goes to see a doctor, they wanted the patient to have coverage when they sue the doctor. So that's why the concept of compulsory coverage exists. But beyond that, there is no real comparison between auto and med-mal. Just it's compulsory to protect the third party. But an argument can be made that almost all forms of insurance are designed to protect somebody if it's not first party coverage. In fact, one of the arguments that was made briefly during argument was about life insurance. One of the justices, I think it was Justice Lavecchia, said, well, what about life insurance? Life insurance is designed to protect a third party. There's a third-party beneficiary of a life insurance policy. Nobody's here suggesting that a life insurance policy can't be rescinded just because you have an innocent third party out there. So that was the kind of comment, very few comments, but that was a very skeptical comment that was made about trying to branch out from the auto arena. So that's I think, the best I can answer that.
My follow-up is, given that you have various industries that are subject to mandatory insurance requirements, but without the non-rescission element that's statutorily in place in the auto context, can you talk a bit about whether or not there are any difficulties in the incentive structure that presents, sort of along the lines of the comment that if you need insurance in order to obtain your license, that in itself incentivizes fraud on applications to some degree?
Well, of course, any time you're going to make something mandatory, you're putting pressure on the applicant to get the outcome that you're mandating. So if you're going to tell lawyers, or at least certain lawyers who have structured their practice in a certain way, you're going to tell these lawyers, you must have insurance, well, then that lawyer's going to sit there filling out the application and say, well, if I answer this question truthfully, I'm not going to get coverage. And then I'm in a box. What do? I can't, if I answer truthfully, I won't get coverage, but if I don't get coverage, I'm violating this particular court rule. And that's a situation that's just a recipe for disaster, because you'd never want to incentivize people to lie on their applications. And you're doubling down on that disincentive if you've told the applicant, by the way, not only do you need this insurance in order to practice, but if you lie on the application, your clients and your customers, your employees, whatever the case may be, they're ultimately going to get protected because the court's going to bar your carrier from rescinding the policy. Once the policy is issued, they're protected, or at least certainly once the incident occurred. It's really, usually these policies only become non-rescindable once there's a claim. So I don't want to overstate it. But once there's a claim, the policy becomes unrescindable, and you don't want to create that incentive. And that's true regardless of whether you're talking about a workers' comp case, where the underwriting is, let's say, different than it is in medical insurance. And medical insurance is different than in a private policy than it is in a JUA policy. So you've got these huge disincentives as it is, or at least these incentives to compel the applicant to get coverage, and then you're telling them, well, if you don't tell the truth, we're going to provide coverage anyway. So that's a real concern for the court, and that was something that was discussed during oral argument.
And actually, another question. I think there was a discussion about, you mentioned about the JUA not being, as a take-all-comers entity, that they are not typically set up to scrutinize applications. I was curious, one, whether you think that would affect the reasonable reliance standards that they would be held to, and two, how that affects the sort of standard to which you might expect them to investigate the one question that they presumably would be responsible for investigating, which is whether or not the applicant is actually has the requisite percentage of business in the state of Rhode Island.
Yeah. So that was actually a question that was asked several different ways during oral argument. The justice, one of the questions that was asked, not rhetorically, was how would they go about investigating that? Now, if the JUA really wanted to know from Dr. Stoddard or any other doctor who applied to the JUA, is it true that your practice is 51% Rhode Island-based? How would they go about investigating that? What would they do? And counsel for the respondent said, well, they could send around a questionnaire to the insurance applicants. And I think the court's response was, well, what's the difference between the insurance, this theoretical questionnaire, and the insurance application? It's essentially the same thing. You're just asking them the same question again. And so I think the court is somewhat skeptical of the idea that the JUA in particular has the ability, and there was some question about their resources as well, and that was something that was being made in argument by JUA counsel, but whether they have the resources, the ability to actually investigate how the doctors spread out their practice. And in fact, one of the arguments that was implicit in some of the questions was the somewhat unique geographic location of Rhode Island. I think everybody understood that Rhode Island's a really small state. A lot of the doctors in Rhode Island have out-of-state patients and out-of-state practices. There was specific discussion of the fact that a lot of them are in Massachusetts in particular and neighboring states. I think everybody understands that New Jersey is not a neighboring state of Rhode Island, but the Rhode Island doctors do have neighboring practices, so that's implicitly understood. So if the JUA implicitly understands that the doctors have some patients outside of Rhode Island, how do they figure out what those percentages are? What would they do? And that question got asked several different ways without, I think, a satisfactory response. But I think part two of my answer to your question is I think the court is going to be somewhat reluctant to go there because those are really questions for a fact finder. And I think the court's going to the extent the court gets into that, the court's going to say, that's why we need to reverse and remand, because we're not going to sit here and say that the JUA, as a matter of law, can't do that, but that's something that the trial court, the fact finder, has to hear testimony on and make some findings on. As I said earlier, I think it's possible the Supreme Court will say that that's not something it can do on summary judgment, that it has to do as a matter of plenary hearing. But I think the court's going to say that is a classic case for taking testimony and making fact finding.
Assume that you get a reversal on the issue of the mandatory limits trumping a rescission claim. Will this decision, in your opinion, have any impact on a case where a carrier is asserting not a defense based on the rescission of a policy, but based on an actual policy defense, such as in the CASAP case, which was an unreported appellate division case from last year that cited extensively to DeMarco in the appellate division, and that dealt not with rescission, but dealt with a policy restriction for listed drivers.
What was the restriction? Policy what?
It was a policy exclusion for unlisted drivers. So in other words, the coverage determination that was being pressed by the carrier did not arise out of a rescission of the policy for fraud, but based on a limitation in the policy based on a coverage provision. And the appellate division cited to DeMarco saying it doesn't matter whether you would be upheld on the restriction, since that type of ambulance or type of vehicle required by regulation $500,000 in policy limits, you are unable to enforce the policy restriction.
Yeah, I think the court is going to say very little about auto insurance. I don't think the court's going to discuss the implications beyond this case and the appellate division's holding. And there was not a lot of discussion. There was no discussion of that case, to my recollection, and I don't think the court is looking forward to trying to figure out what the implications would be of the appellate division's analysis to other spheres and other types of analyses. I think the court has enough on its hands trying to deal with all that they've got here, because, as I said, as I opened, they've got a lot on their plate. They've got to deal with choice of law and the remand issue and the appellate division's core ruling and the amount for the rescission amount if there's a remand. So given that they have to deal with at least those four issues, I don't think there's going to be a lot of discussion about other implications of the appellate division's ruling. Could be wrong.
Thank you, Shalom, again for doing this presentation. We really appreciate it, and we appreciate your doing the amicus brief for New Jersey Civil Justice Institute in this case.
It was my pleasure.